Thanks, Jamal. I realize that we didn't introduce ourselves up here. I'm Larry Alexander from USD. This is Jamal Green from Columbia, and Michael McConnell from Stanford. And Michael McConnell will now respond or comment.
So I don't know why I have two different mics up here. Are you hearing me? Maybe twice? So thanks to Mike and to Jamal for this paper. It's a very ambitious paper. Is it true that this is your first draft?
Yes.
I am floored. It's said that Balzac wrote his novels and then sent them immediately to the printer without ever making any revisions. Well, Jamal could be the Balzac of the constitutional law world. This is a very ambitious, very sophisticated paper. I am going to fundamentally disagree with it, but before I do that, let me note two things about it that I particularly like as the project. The first is that Jamal is confronting something which I think is both factually true and normatively unavoidable, which is that constitutional law does in fact involve a pluralism of interpretive positions. Although I consider myself at bottom primarily an originalist, other things go on, and in part of what we do, other things have to go on, and which leads to the second thing about this, which is that he has a theory here which is a positive theory, but which I think has normative weight. I think he intends it to have normative weight about when originalism is the proper mode of interpretation and when other modes of interpretation are more proper. And he sees that the court over time has been systematically drawn to originalism in particular kinds of cases and drawn to non-originalism in other cases, and that is not random. And I don't care if it's random. What I really don't want it to be is political and tactical, because if the judiciary simply chooses originalism when it's convenient to get to an answer that they want and non-originalism when it's convenient to get to a different answer, this is not an enterprise, at least that I have any respect for. So Jamal is doing us, I think, a very good service in trying to see how a pluralism of constitutional methodologies might actually have an underlying, if not theory, at least an underlying system or predictability or reason behind it. Now, if I understand the paper correctly, and now I'm moving into disagreement, if I understand the paper correctly, cases fall into one of roughly two categories. Either a case raises a question about a constitutional rule, or a case raises a question about the scope of a constitutional standard or principle. And if it's in the former category, judges will be attracted to originalism. If it's in the latter category, judges will be attracted to non-originalism. I think that is not a helpful way to think about cases, because I do not believe that cases do fall into one of those two categories. What I would put forward as an alternative way to think about this is that every case involves both of those things. And then I also don't even particularly, the rules, standards, maybe there is something to that, I can't deny it, but I would just, in my own mind, I find it more helpful to think that every case involves both a question about what is constitutional meaning and also a question about the current practice that's under consideration and how it stands up against the constitutional meaning. And my normative originalist position is that questions about meaning should ordinarily be originalist questions, maybe exclusively, although I'm not going to make that strong claim, but at least ordinarily, and that questions about the current practice cannot, by their nature, be originalist, because we're talking about current practices and what they are, and we need to understand them in the full light of current meaning and circumstances. Now, to illustrate my disagreement here, I'm going to take Jamal gives us 3 examples at the beginning of his paper of cases that fall into the second category, the one about the scope of constitutional standards and principles. He gives us the example first of Fisher versus University of Texas, secondly of Citizens United, and third of the whole women's health case. So let's begin with those examples. Fisher versus University of Texas. And the way he describes this case is, does a public university's race-based affirmative action policy deny the equal protection of the laws to a rejected white applicant? And he indicates that this is a question of a standard or a standard rather than a rule, and therefore non-originalist analysis is going to apply. Well, sort of, I guess, except that I think the first question is, so what does the Equal Protection Clause prohibit? And beginning with a kind of an originalist orientation to this, there's several possible answers. I'm not going to press any of them, but one possible answer is that what the Equal Protection Clause prohibits is governmental action that classifies or treats members of a traditionally oppressed minority in a way that contributes to their continued subordination. There is historical evidence for that. That might even be the meaning of the Equal Protection Clause. If it is, I think the university is on a very strong ground, and we barely even have to worry about the details of the current. We have to spend very little time on the details of the current practice at the University of Virginia, because this is not this rule, whatever it is, doesn't seem to be contributing to the subordination of a traditionally oppressed minority. Full stop, originalist opinion, we don't need to do anything else. Another possible interpretation of the Equal Protection Clause is that it prohibits the use of, that the Constitution is colorblind, that it prohibits the use of racial categories at least as formal, at a formal level. There's also evidence for this. It might even be the correct interpretation of the Equal Protection Clause. If it is the meaning of the Equal Protection Clause, we don't need to spend a lot of time looking at the details of Texas's current practice, because obviously it is not colorblind. It obviously uses race as part of the formal system. It's also possible, and there's evidence for this, that the Equal Protection Clause empowers Congress to decide what is a violation of the substantive provisions of Section 1 of the 14th Amendment, in which case what we would do is look to Congress's enactments. I think the most relevant here would be Title VI. We would interpret Title VI and be off to the races about what is the meaning of Title VI. Now, maybe the meaning of the Equal Protection Clause is that it prohibits universities from using race in any way which is not narrowly tailored to promote the pedagogical values of diversity in the classroom. Now, I've read a lot of the history of the 14th Amendment. I think this is an exceedingly improbable description of the meaning of the 14th Amendment. I think it takes, dare I say, Jack Balkan-esque contortions to get this meaning out of it. But if this is the meaning of the 14th Amendment, then yes, we have to look at the current state of practice in the University of Texas and find out, is it really narrowly tailored? Does it promote diversity in the classroom? What about the 10% plan and so forth? The whole case is going to be about the current circumstances. But my point here is that that is where we are. That's the peculiar world we live in, is where somehow a meaning of the Constitution has come to us that is of this nature. Now, I could make a very similar argument. Since I only have 2 minutes left, I cannot make a similar argument, but I could make a very similar point about each of Jamal's other examples. That is, whether it is a case about a rule or whether it's a case about standards or principles depends. It doesn't come to us because of the nature of the case. You can't just look at a case and say it's one or the other. That is itself the interpretation of the Constitution, which gives us an answer to that, and then we will know whether we need to engage in non-originalist interpretation based upon the evaluation of the current circumstances about the practice. So let me offer as a friendly amendment to Jamal's point of view, the following, that maybe what we observe as a positive matter here is that originalism is more likely than non-originalism to produce a rule. I'm not sure that that's true, but it is intuitively probable, and his examples throughout his paper seem to point in that direction, and that in those cases, it isn't necessary to go on to other things, and therefore, in cases where proper originalist analysis is used, originalism is going to dominate because it produced a rule and we don't need to move forward. That the cases where lots of other stuff is dispositive are all cases in which a non-originalist approach was used to determine the meaning of the Constitution, producing a standard or principle rather than a rule, and then we are, of course, into the swampland of normative considerations of a rather political and subjective nature that don't really, to my mind, belong very much in the courts. So that's my thought.
Jamal, you have a couple of minutes. If you want to use them.
Sure, I'll use them. I won't use all 2 minutes. I'll just respond briefly. And I think the brief response is Michael, being an originalist, is an outlier. And I think everything you said supports the paper, which is that in the cases involving standards, you end up seeing a muddle rather than what Michael would like to see, which is a disciplined originalist inquiry. And so I think each of the cases are a muddle of doctrinal nonsense, and it's been that way from the start. Right? There is no originalist analysis at the court in affirmative action cases. It never has been, even including with Justice Scalia and Justice Thomas. I think that's, again, supports the point. And the only other thing I'll say is I think it's important to distinguish between what members of the court or what court majorities produce in the course of elaborating the Constitution. So sometimes we see rules, and sometimes we see things like standards. That's a different. I think that's a different question. Is under what circumstances should the doctrinal rule be rule-like or standard-like? Is a not unrelated question, but a different question than whether the judge understands the underlying constitutional question to implicate a rule or a standard. So we might see standard-like provisions of the Constitution, like the Equal Protection Clause, devolve into rules. That's a plausible thing to happen, and part of the reason it happens is for reasons not having to do necessarily with the underlying constitutional provision, but for other reasons, judicial discretion or what have you. So again, I think probably the paper could do more to talk about what a judge does downstream with respect to creating constitutional doctrine, but that's a different question.